Testing, testing. Morning, everyone.
Morning.
Good morning, Judge Rovner.
Good morning, everyone.
We're here today for oral arguments. We're going to begin with appeal number 24-1007, United States versus Damon Taylor. And Ms. Kraus, will begin with you.
Thank you so much. Good morning.
Good morning.
May it please the court, Ms. Marin. My name is Michelle Kraus. I represent Damon Taylor as one of his trial attorneys. In a true threat case, the government must prove that the defendant recklessly made the threatening speech with some subjective understanding of the threatening nature of his statement. Counterman versus Colorado determined that the appropriate mens rea for a true threat is recklessness. In the context of a true threat crime, what that means is the speaker aware that his statements are threatening and then he delivers them anyway. In this case, the district court properly instructed the jury on the need for the government to prove the subjective understanding that Mr. Taylor had at the time that he made the statements. The elements of both of the charges that he was charged with were, one, that the defendant threatened to assault or murder an individual. Two, the individual was a U.S. employee. Three, that the defendant intended to impede, intimidate, or interfere with such employee while the employee was engaged in the performance of his or her duties. And four, that the defendant had some subjective understanding of the threatening nature of his statements. In this
Ms.
case,
Crown, may I stop for a moment? Because
yes, thank you.
I certainly can appreciate how the testimony of, from the Fort Wayne police officers, and in particular, the two individuals that interacted with Mr. Taylor at the Park Center might have helped the jury understand that when Mr. Taylor is having a bad day and he gets frustrated, he gets angry with an authority figure, he often makes threatening remarks. But would that testimony have spoken to the issue of whether Mr. Taylor subjectively understood the threatening nature of his statements to the assistant U.S. attorney? It seems entirely possible to me that even if it was routine for Mr. Taylor to make such remarks, that he might have made them precisely because he subjectively appreciated that the recipients would regard them as threatening violence.
Your Honor, it's certainly possible that that evidence would have gone towards proving the mens rea, but what Counterman taught us and is telling us, and in the case that the government cited, the Garner case, in a true threat case, context matters. And so the context of everything that is going on, the government was permitted to bring in 404 evidence. So evidence of other instances or other conduct where that were not on the dates when the alleged, the charged conduct occurred, but they were able to bring in other instances where he either showed up at the federal courthouse, he may or may not have been speaking about the alleged victim, and at times perhaps he was speaking about the alleged victim, but not to the alleged victim.
Can you point us to anything in the proffered testimony of these two individuals, the Fort Wayne police officers, that would have suggested more directly that Mr. Taylor was unable to appreciate or did not appreciate how the targets of his remarks would construe his remarks?
So it was never our intent to bring that information in to argue that he could not appreciate the wrongfulness of what he was saying, because that was an insanity defense or perhaps a diminished capacity defense. And we were very clear that we were not presenting an insanity defense. We were not presenting a deficient mental defense. But again, because
how is that different than establishing that he didn't have a subjective understanding to know he was making a threat? It seems like you just said in response to Judge Rovner's question that you weren't seeking to admit this as to that subjective understanding.
We were seeking to admit it to rebut the government's subjective mens rea.
But how would it do that given what you just said?
Because the totality of all of what he was saying, the totality of how he reacted to other authority figures, the evidence that we were prevented from, the proffered evidence, both from the Park Center people and then from the Fort Wayne Police Department, that not only went to the subjective nature of do I understand what I'm saying is threatening, but it also went to the element in this case of whether or not he was intending to impede, interfere, or intimidate somebody who was acting in their official duty.
Let's take the first element, the subjective understanding. How would his outbursts to authority when he's agitated suggest that he didn't know the threatening nature?
Well,
he's making threats to them, but I don't see anything in those interactions that would support he didn't understand what he was saying was threatening in nature.
Well, he was making threats, and again, we're talking about a time frame within the charging information from May of 2022 to February of 2023. Stay within that time frame, which the government was permitted to do. They brought in some information.
But what the government brought in was different because it dealt with either statements about the assistant U.S. attorney or statements and outbursts that were made when he was at the courthouse. So I think that's different than happening at a police station.
But I think it's that other information is relevant to one of the material elements here, to two material elements, one to the subjective intent. So if it's relevant information, then in order for it to be admissible, we have to go to a 404
So
or 403.
how is it relevant? I guess that's my question, and I think that's what Judge Rovner was getting at as well. The fact that he had these outbursts and made threats to other law enforcement, how is that relevant to show he didn't understand they were threats?
There were never consequences to him when he made those other threats. So, when in our trial, there was information that one of the U.S. Marshals who walked him out of the building on the day that one of the threats was made, that Damon was screaming at him, I'm going to shoot you in the head. That was a federal officer who made a very direct threat, I'm going to shoot you in the head, and all they wanted to do was get him out of the building, and they continued to watch him walk down the street. So there was no consequence to him. And it was similar to when he, the proffered testimony from the two Fort Wayne police officers in late June of 2022 were both very specific threats to those officers, and he was never prosecuted, arrested, or charged in any way. So the lack of consequence means that perhaps he did not understand, because nobody was responding to his threats, and some pretty violent threats, because nobody was responding to them. I think that goes directly to whether or not he understood what those threats were.
It appears that he was able to introduce testimony from the security officers at both the Allen County courthouse and the federal courthouse, who testified that he had threatened them when they wouldn't let him speak to the assistant U.S. attorney. So I guess, to that extent, he was able to show that it was typical of him to threaten an authority figure when they would not give him what he was asking for.
Well, both, the Allen County prosecutor's office, the person who came in and testified about that was how Mr. Taylor got to the alleged victim. Showed up there asking for this person by name, and they said, oh, she's down at the federal courthouse. So under the judge's ruling, it was related enough to this alleged victim that it came in, because that's how he got down to the federal courthouse. And then TFO Demarest, again, that was at the federal courthouse that we were able to talk about, mostly on cross-examination, what was going on at the time.
Thank you.
So to reserve the remainder of your time?
Yes, please.
Thank you, Ms. Kraus. Ms. Marin, we'll move to you.
Good morning, Your Honors. May it please the court. The district court acted within its discretion when it excluded evidence of the defendant's behavior on days other than the days he threatened the victim AUSA and bearing no relationship to that AUSA. Your Honors and defense counsel had previously discussed, what is the relevance of his encounters with the Park Center or Parkview personnel and the police officers. And one thing defense counsel just argued was it shows that there were never consequences to him. I don't think that's borne out by the record. The record reflects that on May 16th of 22, the defendant walked into the U.S. Attorney's office. He actually made a threat directly to the victim AUSA. He was asking her for his documents and she didn't have them. And he said at the end of all of this, something along the lines of he was going to shoot things up or blow things up. And she told him, you can't make threats. And he said, what threats? And that evidence came in at trial. When he came on May 20th to the federal courthouse, he did experience consequences for his actions because the CSOs would not let him up to see the AUSA because the last time he was there, he had made threats.
Now, Ms. Marin, the other side of the coin, why wasn't it relevant and appropriate for the jury to be made aware that the sorts of threatening remarks he made to the assistant U.S. attorney were by no means confined to her, and that there were other occasions and circumstances in which he made similar remarks when he got frustrated with an authority figure? Maybe that doesn't speak directly to his subjective understanding of how the assistant would interpret his statements. But if he regularly made such remarks to lots of people, doesn't that at least raise a possibility that the remarks were a kind of reflex for him and that he didn't necessarily appreciate how they would be received?
Respectfully, no, I don't think so. The fact that an individual threatens multiple individuals and acts in a threatening manner to a cross-section of individuals doesn't tell us anything about his intent with respect to this particular victim, which is what the statute is asking us. Is he intending to impede or intimidate this victim? If he has lots of intents to impede and intimidate other people, that's not really giving us the information we need about this victim. In this particular case, he had a number of other opportunities to learn that the statements he was making were going to have consequences for him. He got barred from seeing the AUSA. He got stopped at the door multiple times at the courthouse. They wouldn't take his calls after he called at the U.S. Attorney's Office. He got interviewed by the United States Marshals in June of 2022 and interviewed about those threats, and he declined to talk about them. Even when, in terms of the evidence defense introduced during the trial, there was evidence that when he was yelling at the Allen County Prosecutor's Guard, so that was Gary Hamilton at the Allen County Prosecutor's Office, he picked up the phone to call 911 and the defendant backed away, understanding, look, there are consequences to my actions. With respect to the record, too, some of the claims made by the defendant is that he regularly engaged in this pattern of bizarre and paranoid conduct, but that's not really borne out by the evidence that he sought to introduce. The Park Center witnesses were not really testifying, and they were not testifying to threats that he had made during their interactions. He had never threatened either of the Park Center witnesses. Instead, they were describing in unmistakably clinical terms that they believed him to be delusional on occasion, and that his mental state varied over the course of their conversations with him. That's not evidence that's particularly helpful to the jury. How is a jury supposed to interpret what being delusional means? How does that give them any information as to whether in these particular instances he understood what he was saying? What that is, and what I think the judge correctly recognized it was, is a backdoor insanity defense, which the defendant claimed on one hand he wasn't introducing, but the only logical conclusion of some of the evidence that he proffered and he claims was wrongly excluded is that that's in fact what he did. And the district court rightly exercised her discretion to exclude that as not helpful to the jury.
Why wouldn't the jury instructions have addressed that concern?
So the district court did instruct the jury that mental health was not a defense. And normally we say that juries are presumed to follow their instructions and limiting instructions are effective. Limiting instructions are effective when we have otherwise relevant evidence. Where I think they can't be effective is if the evidence isn't relevant at all. And you can't put before a jury evidence that's clearly not relevant and then tell them to disregard it. I believe the instruction was that they could consider it only for whether he had a subjective understanding. But on the other hand, that mental health or mental illness wasn't a defense in the case. In this particular case, the district court was rightly concerned that that would just be too confusing for them to parse, especially when the proffered testimony was really evidence, honestly, in the neighborhood of expert testimony evidence. This is not the kind of evidence where somebody comes in and says, look, he came into my office, he was threatening that he was going to shoot me, and he was doing this and he was doing that, and he seemed unconscious. He seemed to not comprehend the seriousness of what he was saying. There was never testimony proffered by the defendant that that was the case, that he would run around making threats and not have a logical connection or a logical understanding of the words that were coming out of his mouth. The trial evidence, all of it, both presented by the government and the defense, showed the opposite. The defendant was a rational actor. He made threats when he didn't get what he wanted, and he made threats to try and persuade people to give him what he wanted.
You know, can I take you somewhere else for a moment?
Sure.
Because I gather that he knew or thought he knew the assistant U.S. attorney from her prior tenure as a county prosecutor. How does that bear on the question of whether he intended to interfere with the performance of her federal duties as an assistant U.S. attorney?
His knowledge of her past career, I don't think bears directly on whether he intended to impede her as a federal prosecutor. It goes to show his fixation with her and his understanding that she, in her role as a prosecutor, was doing something to him. She was trying to frame him. She was holding documents that he believed she had. The only relationship that Damon Taylor and the victim AUSA had was that he believed she was using her office to hurt him in some way, and he wanted to take her time and take her attention to get her to advocate on his behalf or change her position. And he understood that there had been a change, right? That she had been with the state. That's what he told the marshals in June of 22. She had been with the state for 25 years, and that she was now with the federal government. He knew where to go to find her, and he was going to the federal courthouse. There was no mistake at that point as to where he was going and where he thought she was working against him. In any event, even if this court were to conclude that the judge had abused her discretion here, if there was error, it's certainly harmless. The record is full of instances in which defense counsel was able to introduce evidence as to the defendant's mental state, as to some of the defendant's belief about the FBI as a villain in a conspiracy theory, evidence about his angry outbursts on multiple occasions against a variety of authority figures. And in her closing, defense counsel argued that defendant was, by virtue of this, unable to form the requisite subjective understanding. All of that evidence was put before the jury. Unless your honors have further questions, I will stand on our brief and ask this court to affirm the decision of the district court and the defendant's conviction.
Thank you, Ms. Marin. Ms. Krause, we'll go back to you. 2 minutes for rebuttal.
So because context matters, the abuse of discretion that occurred here in creating a one-sided narrative at trial, the government was permitted to bring in the 404 evidence. They were able to argue, and their evidence supported the argument that Damon became fixated on this assistant AUSA, when in fact he had no idea who she was. He thought she had his EBT card, and all he wanted was his EBT card back. The information that that he intended to introduce is sort of your basic 404 evidence. It's interesting that when the judge ultimately ruled that the evidence was not admissible, she found that her ruling was the Supreme Court's opinion can only be understood to say that under Arizona law, as announced in Mott, an Arizona defendant is not prohibited from presenting observational evidence to rebut mens rea. Nothing more is expressly held or reasonably inferred. The defendant here is not charged with an Arizona criminal offense, nor is this court bound by the holdings of the Arizona Supreme Court. Clark does not extend to say anything about the admissibility of observational evidence the defendant is now offering. If the judge misapplied Clark versus Arizona, finding that it was strictly limited observational evidence, and what Clark was talking about is strictly limited to Arizona defendants and Arizona law, then she misapplied that case, and then it's a per se abuse of discretion. And it's also interesting that in finding that all the discussions that were had about the admissibility of that proffered evidence, the judge never directly said it's not relevant. She always talked about the confusion that it would cause the jury. She talked about, she at one point said that the evidence was probative. She said the proffered evidence is not probative and runs the risk of confusing the jury and will not be permitted. If we're talking about probative evidence and we're talking about whether or not it confuses the jury, we've already gone into the realm of a 403 balancing test. Before we get to 403, we have to determine whether or not it's relevant information. We don't get to that until we get to 403. So here, the information was relevant. It's inferred by the judge's rulings, and her abuse of discretion was either per se or harmless. It was not harmless because we were completely devoid of the ability to rebut that mens rea.
Thank you, Ms. Krause. Thank you, Ms. Marin. The case will be taken under advisement. The court is going to take a brief recess and will Good morning again, everyone. We're going to continue now. We are reconstituted as Judge Rovner, myself, and Judge Kolar. We're going to continue with Appeal 24-1524, Citizens Insurance Company of America versus Mullins Food Products Incorporated. Mr. Goodman, we'll begin with you.
Good morning.
Good morning.
May it please the court, counsel. I'm David Goodman. I represent Mullins Food Products in this appeal. This is an appeal from a decision in a coverage action brought by the insurer, Citizens Insurance Company, after it denied Mullins' tender of defense in the underlying case, which is Galan versus Mullins Food Products. Galan is a putative class action that was filed in February of 2021, asserting claims for violation of the Illinois Biometric Information Privacy Act for arising from, in part, the publication of biometric information of its employees in violation of the statute, Section 15D. It's subject to a 5-year limitation. It's been determined to be subject to a 5-year limitations period, and thus it triggers 3 insurance policies, 3 general liability insurance policies issued by Citizens Insurance Company. They differ in a material respect. The first policy, the one from 2015 through 2016, includes 2 exclusions that Citizens relies on as the basis of its denial, the recording and distribution exclusion and the employment-related policies or practices exclusion. And the other 2...
Oh, go ahead, finish your thought.
No. And the other 2 policies also include the access and disclosure exclusion.
Yeah, thank you. The access or disclosure exclusion strikes me as a much more discrete, specific, and straightforward exclusion than the recording and distribution exclusion. What is it about Mitsui's rationale as to the access or disclosure exclusion that you believe warrants reconsideration?
I think that I think it goes contrary to a fundamental rule of construction of insurance coverage, and I think that the issue is highlighted if you look at the portion of the decision that addresses the umbrella coverage, in which the court found that the exclusion did not bar coverage, and if you versus its determination in the primary. And I think that I understand that the sections have different titles, but if you look at the rationale as to the determination as to the primary coverage, the court and its decision was based on a truncated version of the language in that provision. It looked at confidential or personal information, and it failed to account for the things that the insurer had chosen to include in that, and it concludes, of course, with the or any other type of non-public information. So one is left to try to reconcile, what does this mean, any other type of non-public information? Is it including or referring to the list of examples of things that preceded it, which would include, among other things, patents? Patents are plainly not non-public information, they're expressly public information. It's hard, how does one reconcile the terms that are used versus in the umbrella? It was, of course, a narrower, I mean, it had a different title, but if you read it in context, both provisions also talked about the same, the use of this information and the means in which that information, the use of that information would relate to a data breach. So, and again, the court looked at in affirming the district court's finding that the exclusion did not apply generally to BIPA information. it did it based on the title, but I think if you look at the language that's used in both of them and the exclusions itself, in other words, if you judge it not by its title but by the content as well, I don't know how you can reconcile the reasoning. And so that's where we, believe that the Mitsui case was, erroneously decided with respect to the access and disclosure. Both, in fact, if you look at the two exclusions, both expressly use the words access to or disclosure of. And they talk about access to and disclosure of confidential information or personal information. So I find it very difficult to reconcile the two, other than by looking at one has a title that says data breach and the other has a title that says access or disclosure of. That's as we saw, the issue. And I think that the way they were read was read in a manner that's inconsistent with the approach taken by the Illinois Supreme Court in Krishna. Of course, Krishna did not address the access and disclosure endorsement at all, but it offered a paradigm for how one should read policies like this. You have to read them in context. I mean, of course, you do have to account for the title. That's what the court did in part, but it also looked at the language, and it looked at and understanding the other than language in the exclusion that it was considering. It looked at it in the context of what preceded it. So that's an answer to your question. It's a long answer, but that's, I think, the distinction, and I think that's the error made in the construction of this exclusion in Mitsui.
So counsel, just to be clear, you'd ask us to reconsider the Thermoflex holding as to the access and disclosure exclusion.
I would, but I'd also suggest that, and this is an appropriate situation, we have a motion under Rule 52. We do believe that this is an appropriate situation to certify the question back to the Illinois Supreme Court. And the reason is this is an issue that has arisen numerous times. I think it's been addressed in the district court, I think 12 times, and reached different decisions. And the fact that you reach different decisions in and of itself is indication of discord, disagreement. It doesn't prove one is right and one is wrong. It doesn't prove that the Seventh Circuit is incorrect. But it does suggest that this is a recurring situation. It's a situation that involves expressly state law. It is a legal issue.
On that particular question, the certification issue, wouldn't it largely depend on whether Visual Pack and Krishna differ?
Well, I think that I think for a variety of reasons, Visual Pack is incorrectly decided in a manner that's inconsistent with Krishna. But as to the certification of the access and disclosure endorsement exclusion, I think you can certify that and not certify the recording and distribution exclusion. I think it's interesting that in this case, Citizens asks the court, says that certification is inappropriate, but yet says that the two decisions by this court on the access and distribution exclusion were incorrectly decided. How do you reconcile that? I don't think you can. I think that I think that Visual Pack in itself, we go through why it's inconsistent with Krishna, but it would not be a basis for a district court to fail to account this court's decision in Windalco, which was directly contrary to the result that the district court reached. I mean, your question as to certification on Krishna doesn't directly address access and disclosure. It just offers a paradigm for how that court was construing exclusions that are constructed in this manner.
I have a real problem, I must say, with your urging us so strongly, actually with urging us at all, to certify the two exclusions. that are at issue in this case to the Illinois Supreme Court, because it seems to me that Mitsui addresses and resolves both exclusions, one in your favor, one not in your favor. Whatever outstanding questions there, that there may be as to coverage of BIPA claims under other exclusions, I'm not sure. I'm really not sure what Mitsui leaves unresolved for this case. I mean, it's, there may be another case in the future, but.
Well, I do believe that Mitsui resolves the issues, as does Wendalco resolves the issues on the distribution reporting. I mean, I think that if you don't accept that premise, and of course Citizens hasn't, then and if the court, in this case, the lower court, relied on Visual PAC, I think in error, because the issue had been decided by this court in Wendalco, and then of course Mitsui comes afterward and again affirms that no, if you look at Krishna resolves this issue. If you follow the paradigm, it resolves the issue. There's no way of reading Krishna and Visual PAC in a manner that are consistent, and so.
Well, is the recording and disclosure exclusion at issue here, in our case, different in any material way from the statutory violation exclusion that's at issue in Mitsui?
No. It's not, nor is it different in a material way from the exclusion that was addressed in Wendalco. The reasoning, though, of the court in Mitsui, again, put to the side the reasoning in Wendalco and went back again to Krishna and looked at, again, how is one supposed to construe coverage like this?
You say there's no difference, but there's a title change to the exclusion between Wendalco and Thermoflex or Mitsui.
Well, but I think that the language actually used in the exclusion itself is the same. And I think, again, you got to look at, and as the court did in Krishna, Schomburg, it looked specifically at what it was that the insurer chose to include, to identify what it meant. Otherwise, if you didn't read it that way, the catch-all would sort of swallow up the first three paragraphs of the exclusion. There isn't a way to reconcile that. So I think the title may be different, but I think you have to go beyond the title. I think you have to look at the words used, and that goes back to our issue, our concern about how does one reconcile the words used in the two exclusions that were at issue in the access, and disclosure exclusion in Mitsui.
Would you like to reserve the remainder of your time?
Yeah, I would. Thank you.
Very good. Thank you, Mr. Goodman. Is it Ms. Ognabini? Oh, you may approach.
Good morning. May it please the court, counsel. My name is Kelly Onyebani, and I represent plaintiff appellee Citizens Insurance Company of America in this action. The district court correctly held that Citizens has no duty to defend or indemnify Mullins for the underlying suit, and that judgment should be affirmed for 3 reasons. First, this court, of course, has already addressed the access or disclosure exclusion in Thermoflex and found it unambiguously applies to preclude coverage for BIPA lawsuits. Second, the Illinois Appellate Court has clearly now held that the applicability of the recording and distribution exclusion applies to BIPA. And third, the indisputable facts here demonstrate that even setting aside these exclusions, Mullins' 10-month delay in providing notice to Citizens of the underlying suit breached the notice condition as a matter of law.
I'm sorry, your second point, is that on the access or disclosure exclusion or the others
The
exclusion?
recording or distribution.
Thank you.
Turning,
Yeah,
oh, sorry.
May I, I'd like to ask you the same question, if I can remember it, that I asked your friend, Mr. Goodman, which is whether there is any material distinction between the recording and disclosure exclusion at issue here and the statutory violation exclusion at issue in Mitsui. Why is Mitsui not controlling here? And because a rose is a rose by any other name, I call it Mitsui.
Absolutely. Yes, so the exclusion that was at issue in Mitsui, the recording and distribution exclusion, is the same exclusion here. They are materially the same. So our citizens' argument is that this court has expressly held that where the state Supreme Court has not ruled on an issue, the decisions of the intermediate state court control, unless there is a persuasive indication that the highest state court would decide the issue differently. So we now have the Visual PAC decision, and the Illinois Appellate Court's been very clear on where it stands on the issue of the recording or distribution exclusion.
Isn't Visual PAC, though, contrary to the interpretation of the recording exclusion in Thermoflex? Don't they look at it different ways?
In Thermoflex, this court focused on the analysis set forth in Krishna.
Right.
And respectfully did not, I think, fully appreciate the material differences between the Krishna exclusion and this exclusion. And even this court in Wendelco noted that and found that those two exclusions are materially different. So it is our position. Sorry, did you want me to continue?
Yeah.
That Krishna isn't controlling. That is a different prior exclusion. It had a different title. It did not have the Fair Credit Reporting Act. It had a more limited, what we call the catch-all, the final provision. And Visual
As
PAC,
part of our three-dimensional chess, though, you're asking us to say Mitsui Thermoflex controls for one exclusion but doesn't control for another exclusion. We've also got Krishna being Illinois Supreme Court. We've got Visual PAC being in the Illinois Court of Appeals. There's a lot of competing interests here.
yes. With respect to, with Krishna, on the recording distribution exclusion, the Visual PAC is directly on point. It deals with this specific exclusion. And so, yes, we are asking that the Thermoflex decision with respect to the recording and distribution exclusion be overruled to follow the Illinois State Appellate Court. Notably, the Illinois Supreme Court, denied the petition for leave to appeal in Visual PAC. And while contrary to Mullen's assertions, we're not arguing that that's a decision on the merits or that it's precedential. But what Illinois decisions do state and suggest is that the denial of the petition for leave to appeal does give a greater effect and stature to the appellate decision. And that's because when the Supreme Court decides whether or not to grant the petition for leave to appeal, it does so in accordance with Illinois Supreme Court Rule 315. And it has to look at various factors that it considers in doing that, and those include whether there's an existence of a conflict between the decision sought to be reviewed and a decision of the Illinois Supreme Court, whether there's any division within the Illinois appellate courts, and the need for the exercise of the Supreme Court's supervisory authority. So the point being that if the Illinois Supreme Court saw a conflict between Visual PAC and any of its other decisions, including Krishna, the logical conclusion is that it would have granted the review, and it could have done so. It did not do that.
So counsel, we have Wendelco, and then and Wendelco didn't have the benefits of Visual PAC, but then we have Thermoflex Mitsui. Everything you're saying, if it's correct, Thermoflex Mitsui could have taken into account Visual PAC. And what the court did there, it acknowledged Visual PAC, and it took another look at Krishna and came to the same conclusion as Wendelco. So we've now spoken twice on the recording and distribution policy. Are you, and you're asking us to change that based on the Illinois Intermediate Court, is that correct?
Yes, that's correct. To align with, principles of federalism, we have this very unique situation where, as a practical matter, this split between the Seventh Circuit and the Illinois Appellate Court on a matter of Illinois state law, it's resulted in a situation where if there's coverage under the policy depends on whether there's diversity jurisdiction between the insurance carrier and the insured. If not, then Visual PAC is controlling and the insurer has no duty to defend. If there is...
Your clients could also write the policies differently, correct?
Well, the Illinois State Court has found that it unambiguously applies. So it, of course, is a matter of Illinois state law, and this court has, of course, held on numerous occasions that it gives great weight to the decisions of the appellate court when there's no reason to suggest that the Illinois Supreme Court would do otherwise. And that's the position.
Forgive me, because this may seem very simplistic, but okay, let's go through this. The Mitsui Court had the benefit of the Illinois Appellate Court's decision in Visual PAC, nonetheless concluded that the statutory violation exclusion did not apply to BIPA claims. Unless there is some material difference between the exclusion and the recording and distribution, or I should say, I guess, let's see. Unless there's some material difference between that exclusion and the recording and distribution exclusion that's at issue here, what is there left for us to decide that we didn't already resolve in Mitsui?
Well, respectfully, Your Honor, I think that there was little to no discussion at all about the differences between the Krishna exclusion and this exclusion. And the Thermoflex Court hung its hat on the Krishna analysis, but didn't seem to fully appreciate the material differences with that exclusion. So we're asking the court to retake a look at it in light of Visual PAC and the fact that Krishna is distinguishable. It's not controlling. And while Visual PAC is the case that is directly on point with the policy language here.
So because you believe the Illinois law has been decided in Visual PAC, notwithstanding your disagreement in Thermoflex with the conclusion on Krishna, you also are against certification.
That is correct, Your Honor. With respect to certification, it's appropriate where the question to be certified is outcome determinative of the case and where the state Supreme Court has yet to have had an opportunity to illuminate a clear path on the issue. The applicability of the exclusions is not outcome determinative here. The court completely set those exclusions aside and affirmed the district court's judgment that Citizens has no duty to defend or indemnify based on the late notice defense. So for that reason, we don't believe certification is appropriate. But also, this court has repeatedly denied certification, whereas here the state Supreme Court has already been afforded the opportunity to address the questions and has declined to do so. In Visual PAC, that policy had both of these exclusions in them, and the Illinois Supreme Court denied the petition for leave to appeal back in May of this year. For that reason alone as well, certification is not warranted.
So, Ms. Ognebisi, how do we reconcile Visual PAC with our own horizontal stare decisis opinion in Thermoflex? And how do we deal with that?
I think
Because one panel of this court can't overrule another panel. What about that second half of the Thermoflex opinion and how it deals with the exclusion?
I mean, I think, like I said, the case that it wrongly focused on Krishna, and it's Visual PAC that is the controlling law. So we're just asking for the court to recognize that and be cognizant of that. Setting aside both of the exclusions,
Counsel, I just want to make sure I'm getting our decision tree correct. If we find for you on the access and disclosure exclusion, we still need to reach the recording and distribution exclusion because there's certain policy years that don't have the access and disclosure exclusion. Is that correct?
that is correct. Alternatively, the court could find that the breach of the notice condition wipes out coverage under all of the policy years involved as well. But yes, you're otherwise correct.
And do you happen to know which year that is?
It's the very first policy, the 2015
15.
policy, yes.
Thank
Now, with respect to the late notice defense, Mullins has argued in its briefs that citizen cannot raise this defense without having filed a cross appeal. However, the law in the circuit is clear that an appellee must only file a cross appeal when they are seeking to expand their own rights under, the district court's judgment or diminish the rights of the appellant. Cross appeals, however, are not appropriate, whereas here we're just seeking affirmance on an alternate ground. The district court entered a judgment in this case stating that the court declares that Citizens has no duty to defend or indemnify Mullins in the underlying suit. In asserting late notice, Citizens is not seeking to enlarge its rights or lessen Mullins' rights. We're not seeking additional relief, and we're not attacking the district court's judgment. We're just merely seeking to have the court affirm that judgment that Citizens has no duty to defend or indemnify pursuant to either the policy exclusions or the breach of the notice condition. The law is...
Yes. I want to go back for a minute because I have at least two disagreements with Visual Pack. And maybe you can help me. First of all, the court engaged in sort of a sleight of hand at the conclusion of its, swallowing in quotes analysis. It waved away the possibility that some of the personal and advertising injuries purportedly covered by the insurance policy are largely, if not exclusively, statutory in nature and, would thus be eliminated from coverage by virtue of the broad exclusion. Secondly, Visual Pack posits that sophisticated insureds like the plaintiffs there and all of you here would be able to discern from the exclusion that it's meant to address statutory privacy-related injuries, notwithstanding the fact that privacy is nowhere mentioned in the exclusion. And that, for me, it's a fiction. So, why am I wrong? And be careful. Why am I wrong?
Well, Your Honor, I don't necessarily, it's not for me to say you're wrong. It was the Illinois State Appellate Court that made that decision. And this being a matter of state law, I mean, this court has said on various occasions that while you might feel you have the more enlightened, well-reasoned path, and you very well may have, you are still to follow the Illinois law and decisions on the matter, whether or not they are agreeable. I do think, so substantively, that with respect to Visual Pack, I mean, the point that one of the points that the court was making is that there are several common law claims for privacy as well that the exclusion, it doesn't touch, it doesn't eviscerate coverage for those things, and that's important. It's not illusory. Just because the exclusion doesn't cover all things that, I mean, that's what the purpose of an exclusion is. It's always going to limit the coverage provided by the insuring agreement. That's its purpose. And so long as it does provide coverage for certain things, and that still leaves intact coverage for the common law claims, then it should be enforced as written.
Well, in any event, Visual Pack, in the main, distinguished our decision in Wendalco based on a difference in policy language.
That is correct, Your Honor. They did note and find that it was the title of the two exclusions, and the difference there was material. The inclusion of the word recording and information made it more reasonable to construe that exclusion as applying to privacy violations. And that is when the district court in this case issued its ruling, focused on that as well, because that was before the Mitsui decision had come down. But I mean, the court is correct with respect that Wendalco is not the controlling case because the exclusions are different.
Oh my, I think you're all geniuses, you who practice this law. I'm not kidding.
Turning back to the notice issue briefly. So this court, it's well settled that the court can affirm a judgment on any basis that is apparent from its review of the record, just provided that the issue was raised and the losing party had a fair opportunity to contest it in the district court. And the late notice issue here was raised and fully briefed by the parties in the cross motions for summary judgment. So Mullins had a fair opportunity to contest the issue and would not be prejudiced in any sort of way. Mullins, however, has failed to respond to the late notice defense on the merits in its appeal. And so for that reason, we would ask that the district court's judgment be affirmed, even if the exclusions don't apply on the basis that they breached the notice condition as a matter of law. And then finally, the district court correctly granted judgment in citizens' favor on the breach of contract claim. Of course, it's axiomatic if there's no duty to defend, there's no breach of the contract, but the district court initially also found that even if Citizens has no contractual obligation to defend, it necessarily did not breach the policies because it timely filed this declaratory judgment action. Mullins does not dispute that this action was timely filed. Instead, it conflates having a contractual obligation to defend with breaching that obligation. Those two things are distinct. An insurer's liability for defense costs just because it's found to have a duty to defend is not equivalent to having liability for breaching the contract that could include having to cover the any settlement or judgment as well as any other damages that are traceable to the breach. So Mullins is in essence urging the court to find that an insurer must simultaneously file a declaratory judgment action and defend under a reservation of rights to avoid liability for breaching the duty to defend, but that is clearly in direct contravention of well-settled Illinois law that affords insurers either option to avoid breaching its defense obligation. So for all these reasons, we would ask that the court deny the motion for certification and affirm the district court's judgment.
Thank you, Ms. Onyebine. We'll now hear Mr. Goodman from you on rebuttal.
Thank you. I would be remiss if I didn't begin with the last point, or the second to last point, about the late notice issue. The district court concluded its decision on reconsideration, vacating the decision. It's the decision on late notice, it was vacated. It's not subject to appeal. It's not, he made the determination that there was no coverage based on the exclusions and thus did not need to reach the late notice issue, hence he vacated it. So it isn't properly before the court on appeal. Going back I think to Judge Rovner's question about visual pack, I think another important issue to address and why the decision in Windalco is correct is that the court in Windalco, in Krishna, was specifically presented with the question of how it should go about interpreting and understanding the other than language in the exclusion. And one approach was to look at the statutes that were enumerated in the exclusion. The other was to look at the conduct that's identified following the other than language in the catch-all. And the Illinois Supreme Court, the first approach, the statutes identified, that was identified by that was what the insured argued for, and the other was, looking at the conduct as here was what the insurer argued for, and the Illinois Supreme Court said, no, you look at the statutes. That's how you look at the title and you look at the statutes. So again, Visual PAC rejected that. Visual PAC doesn't follow that paradigm. It's wrongly decided. With respect to the issue of the determination on summary judgment, I think that's an important issue that when this case hopefully gets remanded to the district court ultimately for additional proceedings, because at a minimum, the recording and distribution exclusion has been addressed by this court now twice and found not to bar coverage for BIPA claims. In circumstances such as these, where an insurer chooses not to provide a defense, but instead brings a declaratory judgment action, by doing that, it's been well recognized for years and years and years, that in doing so, it preserves policy defenses. We don't contest that. What we do contest, though, is that it gets a free pass. In fact, in this particular policy, and in many policies, the insurers reserve to themselves the right, where they choose to provide a defense and pursue a DEC action, to recoup the defense costs that they've expended on behalf of the insured if they're found not to have owed a duty to defend. The insurer has a choice. Here it made a choice. If the court finds ultimately that Mullins met its obligations in terms of the timeliness of notice and the claim was not barred by coverage, Mullins has incurred the cost of having to defend itself. That is the breach, the cost that it has had to incur on its own, because that's the whole point of the insurance policy. The coverage is to provide for a defense in circumstances like this, but in this instance, Mullins has had to bear that. That's the breach. Finally, going back to the issue about certification. Again, I think that before we get to certification, there is one other thing I'd like to say. I think it's important to bear in mind that, again, the decision by the Illinois Supreme Court not to accept a petition for leave to appeal is not, and it's settled by the Illinois Supreme Court, cases that the insurer ignored, that is not perceived to be, or should not be perceived to be, a decision on the merits, or in any way it's any inference on the matter. The Illinois Supreme Court, for whatever reason, has chosen not to hear this. And to be clear, in Visual PAC, regardless of the number of exclusions that were presented, the only exclusion that was addressed in Visual PAC was the recording and distribution exclusion. It did not address the access and distribution exclusion. But going back to the access and distribution exclusion and why we're seeking certification, it is an issue of great significance to people, not just in Illinois, but it's an Illinois issue because it's an Illinois statute, Illinois law. It's an issue that has been addressed by at least 10 district court decisions reaching different conclusions. In this case, in fact, the judge reached different conclusions based on his diametrically different conclusions as to whether it's ambiguous or not, based on his reading of intermediate appellate court in the state of Illinois. I think, and hence we've asked for certification of the issue because we do think it's an important issue of Illinois law that has not been decided. It is material to the outcome of this case because, while it's not found in the initial policy, it is found in the other two policies. And it does impact Mullen's rights in this case in terms of ultimately, in the event that it goes to trial and is looking to the insurer for indemnification for a judgment. Those policies would be called into play for that as well. For the reasons addressed in our brief, for the reasons I tried to address today, we'd ask that the district court's decision be reversed and the case be remanded for a trial on the merits on the issue of at a minimum, notice.
Thank you, Mr. Goodman.
Thank you.
Mr. Goodman argued Thermoflex Mitsui. Ms. Onyebine argued Windalco. So we've heard from the experts. Thanks to both of you. Case will be taken under advisement. Court will next call Appeal 24-1573, Osborne versus GAB Management Services Incorporated. Ms. Kraus, you can come on up. We'll first hear from Ms. Kraus on behalf of the appellant.
Good morning. May it please the court, counsel. My name is Kara Kraus, and I represent the plaintiff appellant Tara Osborne. The district court erred in granting appellee's motion for summary judgment as to count 1 of plaintiff's amended complaint. The Fair Labor Standards Act clearly requires that employers make, keep, and preserve accurate time records of its employees, and defendant appellee failed to do so with respect to Ms. Osborne. Because the best evidence of her time worked during the relevant time period, February 23rd, 2019 to August 2nd, 2021, is not available, Ms. Osborne should not be denied recovery as a result.
Ms. Kraus, is there in the record before us any evidence that establishes what Ms. Osborne's typical work week was?
There's a couple of pieces of evidence, yes, Your Honor. There is her job description stating that her hours of her schedule was expected to be 8 a.m. to 5 p.m. Central Time, with overtime hours may be required, specifically saying in her job description. There's also a document entitled Agreement Offer of Remote Work, I believe, wherein Ms. Osborne, it was also stated that she was expected to be working during the hours of 8 a.m. To 5 p.m. despite her being a remote employee. And
Where in the record would we find those?
the offer of remote work.
And the
the
job
job-
description, yeah.
The job description, unfortunately, Your Honor, I don't have a Bates stamp number.
Just a document name.
I can, I'm sure it was cited in our recitation of facts. So docket number 21-18, page 13 through 14 would be her 2-page job description, stating that she was, well, first that she was expected to provide 24/7 on-call support, and also that her hours were 8 a.m. to 5 p.m. and with overtime work, quote, may be required.
Ms. Kraus, I'd like to continue on from Judge Brennan's question to you, because what I'm wondering is whether we have, even, looking at your cites just now, whether we have the sort of record that would enable a fact finder to understand what her typical workday or work week was like and why that would typically lead to an overtime of 15 hours a week. Because look, when I look at our cases like our Brown case or Judge Pryor's Young case or Judge Packold's Lee case, I see testimony that gave a concrete sense of what tasks resulted in the plaintiff's overtime hours. In Brown, it was opening and closing the store. In Young, it was that 3-hour round trip to the Monroe office several times a week, and so on. What equivalent evidence do we have here? Will we find it in, the parts of the record that you just cited?
Yes, Your Honor, there's an abundance of evidence. I would say this case is very similar to the Young case, which unfortunately is unpublished, but very on all fours with the facts of this case. Because the plaintiff in that case was also an on-call employee who was expected to provide customer support. She also, in that case, the plaintiff produced, I believe, 16 emails that she sent outside of her regular work hours. In this case, plaintiff has produced considerably more emails that she sent outside of 8 a.m. and 5 p.m. Approximately 70 emails were produced from the relevant time period, which was, again, considerably more than the emails that were produced in Young. There's the travel time as well. There was one instance where the plaintiff, Ms. Osborne, resides in Washington, Illinois, and on one occasion had to drive 10 hours, I believe, over 500 miles to get to a work site that was a jail facility.
But as for the emails, I think that the important point might be, as Judge Mim pointed out, that the emails themselves, they don't establish the amount of underlying work associated with the emails. He said many of the emails are fairly brief. Where are the descriptions of the work time associated with those emails? The mere sending of an email after hours, I don't see how that establishes the extent of her overtime work.
I understand your point, Your Honor. I'd like to point out 3 emails in particular. One email request Ms. Osborne received at 5:36 p.m. on a Saturday. She responded to the client, and 10 minutes later, after 5 p.m., stating, "I'll take care of it tonight." She also received another email from a customer who was unable to log in at 10:26 p.m. on a Sunday. She responded to the customer in less than 20 minutes at 10:43 p.m. "Which laptop are you using, and may I log into it?" There's another email where she was scheduling a system maintenance with a customer to begin at 7 p.m. Pacific time or 9 p.m. Central time. That was on May 18th, 2021. The emails will also reveal that many of the customers that she corresponded with were in different time zones in states like California, Michigan, and Ohio. Particularly, all of the servers were physically located in California, and she often had to correspond with a team of employees who worked for a company called Data Resolution. All of those employees were also based in California, which of course is in a different time zone, and that'll be reflected in the emails as well.
And for the record, which docket entry are you reading from?
Unfortunately, I don't have the record for those.
Even the label of the document would be helpful.
Right. So So all of the after hours or outside of regular business hours, those emails, those are all found in docket 21 -17 and ranging from page 17 to 98. So those are where the emails can be found.
Thank you.
Yeah, well, there certainly is evidence of work conducted outside of normal business hours. But what I found missing would be evidence confirming that the after hours work resulted in work that exceeded 40 hours a week. That's what I think we have to zero in on. You know, she was working remotely. She was responsible for setting her own schedule. I hope that we can find some more detail as to her day-to-day work.
I understand, Your Honor, and it's important to also keep in mind that we're talking about an employee who was terminated, and at the time of her deposition, which was more than a year after her termination, she no longer worked for Appali. So she was testifying based on her memory and her recollection of the job duties she performed the prior year, and how often, how much time she spent doing so, which is difficult. But the just and reasonable inference standard is a low evidentiary burden. So in addition to her deposition testimony, I rarely did not work at least 10 hours a day. She testified I worked at least 10 hours a day and on weekends. So in addition to that deposition testimony, which again was, she was testifying based on her recollection, which is fine, because hours works can be reconstructed from memory. It can also be inferred from the particulars of her job, which is also important here, given that she was, in her job description, it stated she was expected to provide 24/7 on-call support, and she was the only employee doing so for the nation's largest jail contract management company for over a year. She had one counterpart who ended up resigning in February 2020, and no one was hired to replace him. 2 other employees also resigned. And no one else was hired, including a director of information technology, and that position was vacant.
Now, counsel, the district court here also noted that the talk of averages and the computation was somewhat undercut by your client's acknowledgement that things changed, that a software glitch was fixed, that some of her work was shifted. How do we address what the district court found to contradict your client's estimate?
Right. So I believe the district court did err in concluding that her testimony was unreliable and directly contradicted by the record. I think something else the district court focused on was the fact that she took sick time and PTO leave for, I believe, around 10 weeks during the relevant period. Of course, plaintiffs can meet the just and reasonable inference standard even if they worked no overtime at all during some weeks of the relevant time period, and any sick time and paid time off can, of course, be accounted for by a fact finder. There was, I believe you may be referring to, Your Honor, to there was a couple of employees who were, I believe, hired to take care of some of her calls, but she testified at her deposition that they were never able to troubleshoot anything, and the company at one point relocated to Tennessee, and those employees were terminated. So it didn't seem to me from the record, or a reasonable fact finder can find, that no one actually was hired to take the load off and assume some of her responsibilities. In fact, there was resignation after resignation, and no one was hired to replace the employees who were resigning, which also was the case in Brown, where the employee was the only person who was there to open and close the store. Again, plaintiff Ms. Osborne was the only one providing on-call support to customers. defendant appellee has the burden, it's a burden shifting framework, and the framework simply addresses whether a reasonable fact finder can find a basis for calculating damages. And defendant has the burden to come forward with evidence to negative the reasonableness of the evidence that Ms. Osborne has proffered, which it hasn't done.
Ms. Kraus, we're going to give you some time for rebuttal, but the legal question here, a couple times you've mentioned just and reasonable inferences. There is case law out there that indicates that that standard applies to damages rather than liability. Is it your position that just and reasonable inferences applies to both liability and damages, or what is your position on that?
I think liability has been established here. I think, again, the only question is whether there's a reasonable basis for calculating damages. The damage itself is certain, and the only uncertainty lies in the amount of damages. That's from the Anderson case. So again, it's a low burden of proof, and I believe that Ms. Osborne has produced a significant amount of evidence, even more that was produced by the plaintiff in Holloway, an Eighth Circuit Court of Appeals case, which I believe the district court erred in citing and relying on. And the rule of law in this circuit is Brown, in which the plaintiff was unable to identify the hours or the days that she worked overtime, but she was still found to have met the just and reasonable inference standard. And for those reasons, plaintiff respectfully requests that this district court's decision be reversed and remanded. Thank you.
Thank you, Ms. Kraus. We'll be giving you a couple minutes for rebuttal. Mr. Buck, you are next for the appellee.
Thank you, Your Honors. May it please the court. I want to jump in kind of in a different issue than we've been talking about most directly just now, but to point out that there was an issue over the compliance with local rule 7.1D in this case, and specifically the issue with regard to the local rule was whether there was an abuse of the discretion for the court to find that the motion itself, that the plaintiff's amended response in fact violated the rule by the manner in which she responded to the statement of facts, and specifically those that were listed as undisputed material facts. The court, after looking at rule 7.1D B2, actually pointed out that the rule itself requires for the non-moving party to look at and to respond to each of the individually numbered facts to say whether they're disputed or undisputed and whether they're material or immaterial. And in this case, when the district court looked specifically at the initial response of the plaintiff in this case, that original response did not respond individually by number to the individually numbered statements of material fact, and in fact, basically the plaintiff created her own list of just undisputed material facts.
Mr. Buck, look, the court deemed your proposed facts admitted, right?
Yes. One of the reasons I wanted to go there, Your Honor, is in counsel for the plaintiff stated a moment ago that when she was asked by this court what was she relying upon as far as in the docket or in the record for the facts that she was asserting, and I believe what she said was she was looking at docket entry number 21. Docket entry number 21 is the initial or the original response to the motion for summary judgment filed by plaintiff. It bears that 21-18 docket number. That was stricken by the order, this court's March 11th, 2024 order. Actually, I think even before that.
Not this court's, the district court's.
Pardon?
The district court's.
Yes. The district court's, after the motion for summary judgment was filed March 23rd, 2023, on April 13th, the Plaintiff Osborne filed her response, her initial response to the motion for summary judgment on April 27th, 2023. JAB Management filed its reply in which it noted that the plaintiff had failed to respond to the undisputed material facts raised by JAB in compliance with Rule 7.1, Local Rule 7.1 D2B. On May 22, 2023, the district court struck that response, the initial response of the plaintiff to the motion for summary judgment. And then on June 5th, she was allowed to file her amended response, which was docket number 28. And the court then, in its March 11th, 2024 order granting summary judgment to the plaintiff in this case, noted that both the original response brief had been struck from the record, as well as the amended response to the undisputed material statement of facts, which basically covered the first 78 paragraphs of the statement of facts. I'm sorry, the motion for summary judgment had 78 individual paragraphs. Their the amended response itself, which was responding only to those numbered paragraphs, was also stricken. So you had the original response to the motion for summary judgment was stricken by the court by the March 11th, 2024 order granting summary judgment.
What do you want us to do about it?
What I'm going at is the plaintiff has failed to meet her burden almost entirely. She hasn't raised any evidence. She's referenced, when you've asked her for support for specific evidence to corroborate her testimony of working on average of 25 hours a week beyond 40, she cited to a stricken response, a stricken amended response to disputed material facts. So the bottom line, what I wanted to point out to the court is that we're not looking at actual facts that are still in the record. Then I would also point out to the court that, you know, the case law that's cited by the plaintiff itself doesn't support the notion that testimony, you know, the phrase that's been used is that it takes more than unsupported ipsy-dixit or bare assertions in order for the plaintiff to meet her initial burden to come forth with sufficient evidence that overtime hours were worked as a matter of just and reasonable inference. What the plaintiff is basically...
Would you just do me a favor here?
Yes.
And just pretend, okay, for a moment that you are Ms. Osborne's lawyer, okay? Would you give me an example of the sort of evidence you would present in order to meet the just and reasonable inference standard as to the extent of her overtime?
The difficulty with that is trying to understand, but given the manner in which she responded to since I'm the plaintiff's lawyer, to the defendant's undisputed material facts, in not individually responding, not saying what was correct or what that was disputed or what was material, it makes it very difficult to go back and look, particularly at the statement of facts and her initial response and the statement of facts, her basically amended response to the statement of facts that were put in there, to decipher what it is that she's pointing to. She does point to emails, although frankly I would note that she was hired in 2012 by the defendant JAB Management. She continued to work for them up until August of 2020. For purposes of the motion for summary judgment, the defendant conceded that the relevant period, number one, conceded that she was non-exempt, and also that the 3-year look-back period for a willful violation would be applicable, so that you could look back from August 2021 when she was terminated to August 2019. Where I was going with that is many of the emails and many of the things she's referencing to support that she worked overtime are even beyond the relevant period itself, because she worked for the defendant for such a long period of time. So, moreover, the emails themselves don't actually say how much time she spent. It may show that she worked outside of normal hours, but it does not state that she had already worked 40 hours that week. She worked from home starting in 2019. She was allowed to set her own schedule. Pursuant to that, her own supervisor, the president of the corporation, had no idea what she worked. call hours were to be part of her responsibility, but at the same time, it wasn't known if she had already worked 8 to 10 hours when she took a call at midnight or took a call at 1 in the morning, or did she work evenings that day, or did she work overnight that day? So there's nothing in the emails themselves that corroborate that she was exceeding 40 hours a week with the handful of emails. And some of the emails that were relied upon in producing the discovery, again, go back prior to 2019, so they're not relevant or material to the question before the court.
Mr. Buck, I want to take you in a different direction, similar to a question I posed to Ms. Kraus. Ms. Kraus cited actually the key passage from the Anderson case, 1946 Supreme Court decision. Just and reasonable inferences, do you believe it applies just to damages or to liability and damages? That's standard.
My understanding of Anderson and the way it's been applied is it goes to damages primarily, and that the plaintiff has to show that the hours worked is the element of damages in the event that there's the claim made. I'm thinking of particular language in some of the cases that we cited.
We've got the Brown case, obviously, from 2008, which
Yes.
which alludes to this question. And I'm specifically thinking about the context of the standard that's to be applied by this court, just and reasonable inferences. Would that be to the factual record, whatever it may be, and you elucidated us on what you believe that to be, or the damages?
And I do believe, and I did find in the Brown versus Family Dollar Stores case, at page 595, they do say that the plaintiff must establish damages, and that task is not a difficult one if the employer has not kept records in compliance with the Fair Labor Standards Act. And that's where the Anderson court then proceeded on the notion of proving damages to say that the plaintiff employee had to come forth with sufficient evidence to show that they worked the overtime hours as a matter of just and reasonable inference. Now, as to the question of what that means, I think the Seventh Circuit and the authority we've cited by the Seventh Circuit, even beyond Holloway, sets that standard. Melton versus Tippecanoe, again, this circuit said that there must be more than basically uncorroborated testimony of the plaintiff. And in Melton, this court found that the employee had failed to produce evidence in which to draw a just and reasonable inference, because although he claimed that when he would give recorded overtime on timesheets to his secretary that she would reduce those and give us back, that she corrected all of his time cards. That was primarily the evidence, and the court there found that, again, he may not rely on unsupported ipsy-dixit or bare assertions. Melton cited to Turner in the Turner versus the Saloon, the 2010 opinion from this circuit. The plaintiff was a waiter at the, I'm sorry, Your Honor, did you have a question?
Just following up on Judge Brennan's question, the Anderson test,
Yes.
There's liability and then there's damages. But under Anderson, we're also talking about the amount and extent of the work being established by just and reasonable inference. What do I do if I say, okay, I think that it has been established that there has been some violations. There are weeks where the plaintiff worked overtime, was not paid. But I am not able to determine on the record a just and reasonable inference as to the amount of that, as to what the damages should be beyond speculative. Where does that leave us?
I think that leaves you in the position we're in today anyways, that plaintiff has failed to prove her case. She failed to prove damages, which means she can't recover. She cannot meet her initial burden, as lenient and relaxed as it may be, of showing damages as a matter of just and reasonable inference. She's not entitled to recover those damages. And I think what this circuit, through Melton, Turner versus the Saloon, Brown versus Family Dollar Store, which actually the Brown versus Family Dollar Store, the court did award damages, and the court did look at more than just the testimony. In fact, that the testimony of the plaintiff in that case was in fact corroborated by other evidence, certainly more objective evidence, and that was that employee who worked at Dollar General was the only one with keys to that particular store. So she had to open the store, she had to get there early, she had to close the store, she was there late. And
So here the record before us, and docket 21, I think, is your summary judgment papers, so that's in the record, it wasn't stricken. And there's references there to her work hours being 8 to 5. And so we have a situation where it sounds like you expect her to be at work for a 40-hour work, and there's evidence properly in the record saying she also needed to do things outside of work hours.
in my position on that is, again, you look at the fact that this employee worked from 2012 to August of 2021, and in 2019, she was allowed to work remotely and work from home. Now, when she was expected to come into the office hours of the JAB management facility were in fact 8 to 5, and that's when she was expected to be at work. Ultimately, JAB Management and ACH, the company that they provide employees to, moved to Nashville, Tennessee in it was right around the 2019-2020 time period. And again, plaintiff was allowed to remain in the Peoria area where she lived and worked previously, and also to work from home and to work remotely. At that point, she didn't have the 8 to 5 requirement. She was allowed to set her own schedule for what worked for her. I will also note that, again, with regard to the claims about the overtime that she was working on taking the help desk call, there's also evidence that we cited in the motion for summary judgment that by February, March of 2020, when the other 3 employees she worked with had resigned, there was also an error marking function put in the electronic medical records software that she testified on her own tremendously reduced the number of help desk calls she took and the time it took to resolve them. So again, the period that we're looking at is 2021 back to 2019, and early 2020, she's acknowledging that the volume of calls was tremendously reduced. We also cited emails where Sue Webster and Jessica Young were asking her what her hours were on help desk calls, and she responded, well, sometimes I get them, sometimes I don't. And, it varies as to how much time I spend on them. So again, although she testified she took help desk, and there's evidence with emails that she answered those after hours, there's also evidence to contradict that she was working extensive amounts of overtime, as she claimed, 15 to 25 hours a week on average. I mean, it was like 15 during the week, and then she would have anywhere from 4 to 16 hours on the weekend. And
Thank you, Mr. Buck. Thank you very much. We'll now hear Ms. Kraus from you. We'll give you 2 minutes for rebuttal.
Thank you. I'd first like to address some of the procedural points that opposing counsel made. Ms. Osborne has, of course, limited her appeal to the grant of summary judgment as to the count 1 of her amended complaint. Ms. Osborne also limited to her appeal in the way that she's not arguing that there was an abuse of discretion with respect to enforcement of local rules, because that's a very difficult argument to make, and we're not making that argument. The district court did not strike plaintiff's additional material facts, and also it was defendant that was the one that introduced over 500 pages of evidence, including all of the emails that I referenced. Opposing counsel also mentioned another case, Melton, which is very factually different from this case. In that case, the plaintiff's time cards were automatically reduced to reflect 37.5 hours. Now, if you look at the time cards in the record for Ms. Osborne, they reflect 40.0 hours. So in that case, the plaintiff was actually able to prove that he worked an additional 1 hour and 40 minutes beyond that 37.5. The issue was it still wasn't over the 40-hour threshold. The plaintiff in that case also created a spreadsheet from his memory of the hours that he worked, which was directly contradicted by the payroll records that were introduced in that case that reflected he was in fact compensated for some lunch periods that he alleged not to be compensated for. I'll also address the implication that the president of this, I believe Jessica Young, who never actually supervised Ms. Osborne, so of course she wouldn't have an idea of the hours that she worked or really a good idea of what her duties and responsibilities were. Ms. Osborne's declaration makes it clear that she was never supervised at any point by Ms. Young.
Thank you, Thank you very much, Ms. Kraus.
thank
And thank you, Mr. Bach. The case will be taken under advisement. We are now going to move to appeals 24-1228 and 24-1229, United States versus Wesley White Jr. And Mr. Browiak will move to you first.
Thank you, Your Honors. May it please the court, counsel. Your Honor, my name is Zachary Browiak. I represent appellant Wesley White. In this case, appellant makes 2 points on appeal. The first one is that the district court erred when it allowed the government to withdraw from certain portions of the guilty plea agreement. The portion itself had to do with the government making a sentence at the low end, or making a recommendation at the low end of the guideline range. The error came in when the government relied on evidence that could be considered unreliable in order to support that decision, granting the government leave. It's that unreliable evidence that dovetails into the second point that's made, is that the district court issued an unreasonable sentence in sentencing Mr. White to an aggregate sentence of 194 months with the Bureau of Prisons. So the unreliable evidence in this case were essentially emails that were presented at the sentencing hearing. Those emails were from a woman named Tamara Plummer, and they were brought to court via a testimony through an agent through the Illinois State Police. So to step back for a second and just sort of go through a procedural background in this case, Mr. White pled guilty to 2 counts of felon in possession of a firearm between sentencing and between his guilty plea and sentencing. Mr. White was additionally charged with murder in the first degree and armed criminal action in the city of St. Louis.
You don't represent him in that case.
I do not represent him in that case, Your Honor. I represent him through the CJA panel and the Seventh Circuit here, and he's represented privately in the murder case.
Obviously, he's got a lengthy sentence with regard consecutive sentences in this case.
Yes, Your Honor.
As I understand it, that Missouri state homicide charge, it remains pending and he's in bench warrant status with regard to it?
That's correct, Your Honor. He's now doing his time with the Bureau of Prisons, and there's a warrant pending in the city of St. Louis without a trial date at this moment.
Thank you.
Yeah. So,
Mr. Borowiak?
yes, Your Honor.
Why isn't his marijuana use enough by itself to support the district court's decision to relieve the government from its sentencing obligation? I mean, it's true, you point out that the government didn't cite marijuana use as a basis for the motion, but Judge Dugan did raise it on his own. And I gather there's no dispute that he, in fact, did use marijuana.
Your Honor, there is no dispute that Mr. White did, in fact, use marijuana. I would point out that it was the basis, and I think you had mentioned this as well, the basis of the government's notice to withdraw was, in fact, the murder investigation, and the marijuana and the issues that were raised via the emails were sort of stumbled upon during the course of the sentencing hearing itself. I think Judge Dugan used the phrase low-hanging fruit, but I think when you get further from the marijuana, which I think was discussed that is rarely used in order to revoke an individual or have such an impact as it did here in this case, I think that sort of gets to two things. It talks about sort of the substance behind the government's ability to withdraw from the guilty plea agreement, but it also goes further into the unreasonability of the sentence itself. I think the district court mentioned that the marijuana use was something that was on sort of the lighter side of sort of violations, but the emails themselves, they were from Tamara Plummer, who was the victim in the homicide case, and there was no real opportunity to further investigate what was behind the emails. The evidence was sort of given to the court in a two-dimensional landscape.
Counsel?
Yeah, I mean, I realize that no one had an opportunity to interview her, but she wasn't an anonymous source. She had a relationship with him, and she was in a position to know if and when he had possessed a firearm. And she expressly said that the photos and video attached to her last email were taken within the prior 30 days. So what exactly precluded the judge from relying on her statement?
Sure, Your Honor. Sure, Your Honor. I think one of the things that you mentioned there was that she did in fact know Mr. White, but one of the things that's discussed in the case law is the ability to cross-examine one of the witnesses when you're assessing the reliability or accuracy of the information. The fact that there was a prior relationship there, I think opens it up to, what potentially could have the bias have been. That bias sort of makes it more difficult to understand when you're not just, going from an email saying, hey, this was taken, to figuring out sort of the context behind it and the reasons why the pictures were taken.
And counsel, from your briefs, a lot of what I think you would cross on was focused on when those pictures were taken. Assuming that the government can withdraw from its agreement regarding its sentencing recommendation based on the marijuana use, that timing to me becomes much less important. And what is there that the district court here used at sentencing that in and of itself was unreliable, so wasn't related to the timing of when those pictures and the emails were taken?
Sure, Judge. I would argue that the emails as a whole in themselves were unreliable. Essentially, you couldn't really follow up with what was really any context behind that. I know I did talk about the timing with Agent Woodiel as far as there's no timestamp there, but I also asked him his opinion, because you have to remember, he's the one that's actually bringing this information to court as to when he thought these pictures would have been taken. And he just sort of goes with this blanket statement of, I have to assume they're old. And without any further corroboration or being able to speak with the person that generated those emails or that media, I think it makes it much more difficult to find the pictures and what they're sort of purporting, what the truth of the matter is that they're bringing out, to be that much more unreliable.
Would you like to reserve the remainder of your time?
I would, Your Honor.
Thank you, Mr. Borowiak. Ms. Ruppert will now move to you for argument on behalf of the government.
Thank you, Your Honors. Good morning. Laura Ruppert on behalf of the United States. May it please the court and counsel. The district court did not clearly err in finding that appellant violated federal law in breach of the plea agreement. After a lengthy evidentiary presentation in support of the government's notice to withdraw from its sentencing recommendation, this court declined our request to make a specific finding as to the commission of homicide, and instead made two factual findings. First, that the appellant, Wesley White, possessed a firearm sometime in late October or early November of 2022, and second, that he possessed marijuana on December 28th of 2022. It cannot be said that these findings were erroneous, let alone clearly erroneous. Judge Rovner, as to your comments or questions to counsel for appellant, you're exactly right. The possession of marijuana on December 28th, 2022 was uncontroverted. There were a number of bond violations committed by appellant that were included in the pre-sentence investigation report,
One of those being his possession and usage of marijuana on December 28, 2022. At the sentencing hearing, Judge Dugan commenced it by asking Mr. White if everything in the pre-sentence investigation report was true and accurate, with the exceptions of those things that were being actively challenged by way of PSR objections. And Wesley White replied in the affirmative. And so Mr. White acknowledged to the district court that he violated federal law on December 28, 2022, which is a clear breach of the plea agreement.
With respect to Mr. White's marijuana use, tell me this. When there is a conflict between federal and state law as to the legality of marijuana use, does a defendant realize he may be committing a federal offense when using marijuana regardless of what state law?
I think that he is charged with having to know that he's violating federal law. And in fact, I know it is our common practice of our magistrate court judges, as well as United States Probation Office, that they specifically advise defendants while they're on pretrial release that usage of marijuana is in violation of federal law. And in fact, he would have had that knowledge because there were consistent bond violations that were submitted to the court with no judicial action taken. So Mr. White would have been charged with that knowledge that usage of marijuana was a violation of federal law by virtue of his repeated violations while on bond, including that final one that took place after he had pled guilty pursuant to the written plea agreement. With respect to the possession of a firearm, again, in late October of 2022, early November of 2022, I think it's important in assessing these emails what they weren't and what they were. Tamara Plummer did not email the Illinois State Police, the United States Probation Office, or the U.S. Attorney's Office simply making a statement, Wesley White possesses guns. She included photos. And those photos, and specifically the ones that were submitted to the U.S. Attorney's Office on November 12th of 2022, she specifically stated these were taken recently within the last 30 days. To back up for additional context, that statement is relevant and the court can rely upon that statement because there was this ongoing dialogue of trying to assess when the first photos sent to United States Probation and sent to the Illinois State Police, we were trying to assess when that photo was taken. And specifically the photo that was included with the email to United States Probation Office on September 30th of 2022, Tamara Plummer specifically stated, Wesley White is threatening me with this firearm. He's threatening to kill me. And so she's saying that he's possessing this firearm and also using it to threaten her. When she sends this email on November 12th of him in possession of a firearm and says these are within the last 30 days, the district court had every ability and every reliance on that as being reliable evidence that it was taken within the last 30 days. So these photos included with the emails showed that corroboration that it was clearly Wesley White in possession of a firearm. And then the timing and the additional statements that she made, in addition to the fact that she ended up dead on January 13th of 2023, just after being with Wesley White not 45 minutes earlier, again, all can go to the district court's conclusion that Wesley White possessed a firearm in that time frame. So again, there was no error by the district court to rely upon that evidence. Certainly, again, it was not clear error. As it relates then to the substantive reasonableness of the sentence, the district court did what it was supposed to do, which was evaluate the 3553A factors and select a sentence that was sufficient but not greater than necessary. And a district court abuses its discretion on sentence when it resolves an issue or a manner in a way that is fundamentally wrong, arbitrary, or fanciful. The court didn't do that here. The court analyzed the factors of 3553A and determined that the defendant, Wesley White, was a danger to the public. And it explained its conclusion, talked about the numerous prior convictions and adjudications where Wesley White was in possession illegally of firearms. A prior offense and one of the instant offenses showed him to be a trigger puller. One of his priors, he was shooting at a target affixed to an abandoned house in East St. Louis. One of the convictions in this case, he was at a firing range or a shooting range in St. Louis with a semi-automatic firearm with a 50-round drum magazine. And in both of those cases where he's firing at these targets, he's posting them on Facebook. He talked about the nature and circumstances of these instant offenses, that there was an idiotic, quote, idiotic attempt to obstruct justice, that he was trying to conceal firearms from law enforcement agents, and he eventually admitted that he got that firearm back and then he, quote, traded it on the streets. The district court commented on Wesley White's membership in a violent, notorious street gang in East St. Louis, JDS, which is short for John DeShields. So yes, the court referenced these photos of Wesley White that were provided by Tamara Plummer, but this was just a portion of an overall examination of the 3553A factors, concluding that Wesley White was a dangerous person, could not be deterred from criminal conduct, future criminal conduct, and ultimately selecting a sentence of 194 months in the Bureau of Prisons. This was not an abuse of discretion. So unless there are any further questions from this court, we would respectfully ask this court affirm the sentence of the district court.
Thank you, Ms. Repper.
Thank you.
We'll now move to Mr. Borowiak for rebuttal argument.
Yes, Your Honor, may it please the court. Your Honor, it was stated in the government's argument that as part of the corroboration in these emails is this idea that Ms. Plummer sends these pictures, and then a few months later, Ms. Plummer is found dead. I think it's important to point out, just here with the court right now, that the district court was very reluctant and decided not to make a finding as to whether or not Mr. White was guilty of the murder charge. I think what I'm trying to get to here with the court today is the fact that what's within these emails is considered unreliable, and it sort of taints the reasoning past the items that were from the PSR, where I think the government just came up here and talked about gang violence and the such, but without sort of the consideration of what's contained within these emails, I think you can't get to the point where the Mr. White is now serving a 194-month sentence. Essentially, the court went at length to talk about what was inside the emails and what conclusions that it drew from those, including it thinking that Mr. White had committed another felon in possession of a firearm case. But when we step back for a moment and we look at sort of whether or not the evidence that was presented in the emails contains a significant indica of reliability, I'm sorry, I was looking for the right phraseology there, courts have looked at sort of what creates this indica of reliability. And I think what it looks at is there forms of corroboration? Is there an opportunity to cross-examine? Is it supported by any other evidence? In my reply, I focused a lot on the Hankton case. And the reason I did that was because it's very similar to some of the other cases that are discussed. But one of the things that's in there is the government in that case was looking to basically reach a certain amount of drug weight. And there was testimony from individuals who were familiar with the acts of that case itself. This wasn't sort of an uncharged conduct matter. And then there were a series of other pleas and information from other individuals. I think the same is true sort of the Smith case that I referenced in my brief right after Hankton, where the court is talking about the number of people that had testified and the amount of information that was provided to the court for it to come to that conclusion, but also the opportunity for defense counsel to cross-examine and get further into those conversations. Your Honor,
Thank you, Mr. Borowiak. And thank you, Ms. Ruppert. The case will be taken under advisement.
Thank you, Judge.
Judge Rovner, with your permission, we'll take a brief break.
Thank you very much.
Thank you. We're back now with Appeal 23-3415, United States versus Eric Kyrimi. We'll hear first from Ms. Gambino.
Good morning, Judge
Morning.
Brennan, Judge Rovner, and Judge Kohler. It's my privilege to represent Mr. Eric Kyrim today before this court. We bring two issues before you. The first is whether the district court erred in determining that a charged but dismissed count was a proper basis for relevant conduct. And the second is whether or not the judge violated Mr. Kyrim's due process rights when it first agreed to provide a decision on the relevant conduct issue before sentencing and then did not go forward with that agreement, resulting in Mr. Kyrim being unprepared to deal with the judge's decision at sentencing and the judge taking certain aspects of that disadvantage against him in imposing her sentence. So with respect to the first issue, Mr. Kyrim pled guilty on the second day of trial to count one of the indictment against him, which charged a wire fraud involving investors in an alpha investment fund. And the nature of the facts to which he pled guilty was that he had created a newsletter or borrowed from a newsletter by another investor and used that newsletter to provide information to his investors, knowing that that information was false. The second count, which he did not plead guilty to, involved a completely separate transaction between Mr. Kyrim and a man named Da Zhao. And the nature of their transaction did not involve the Alpha Fund. It involved a direct investment into shares of a going concern, Restore Flow Allographs, in which the Da Zhao wanted to buy shares of that particular concern. And while at first the concern was going to have an open call for capital, when Mr. Kyrim and Mr. Da Zhao were first discussing this, the company later decided it would not go forward with the open call, so Mr. Kyrim offered to sell a portion of his shares to Mr. Da Zhao. So there was no connection between the wire fraud alleged in count one and the conduct in count two. In order for that conduct in count two to be relevant conduct in the case, according to the sentencing guidelines, it had to involve a common scheme and plan, or it had to be connected or otherwise related. And it's our position that it was neither of those two options. First, when considering whether there's a common scheme or plan, you look at the nature of the fraud, which in this case involved separate types of investment vehicles and not the same type of investment vehicle. It involved different alleged victims. There was no common purpose. There was no similar modus operandi between the two, or no common accomplice. They were completely separate. As far as them being connected or related, it is Mr. Kyrim's position that they were not. The government took the position, and the court adopted it, that because after the purchase of the shares of the transaction between Mr. Kyrim and Mr. Da Zhao, Mr. Kyrim took part of the purchase money that was provided to him by Da Zhao and invested it in his own alpha fund, that created the connection. However, that cannot be the case because there was no other evidence that deposit of funds into his own investment account constituted, or that he intended it to be funds to cover up the losses that were suffered by his first investors, other than the fact of the deposit. And in fact, the fraud, if there was one, and it was Mr. Kyrim's contention that there was not, between Mr. Da Zhao and himself, would have occurred in him not following the memorandum of agreement that the two had signed, and had nothing to do with the disposition of the funds. The fact of the matter was that Da Zhao had purchased shares of funds, and he was going to get a return on those funds when the company itself had been bought out or otherwise disposed of. So in the first instance, count two was not properly considered to be relevant conduct to count one. And that was important for two reasons. The first is that it affected Mr. Kyrie's guideline calculations. There was a two-level difference in guidelines depending on whether the amount of money involved in the transaction between he and Dao Zhao was included with the loss to the other investors. And so the difference was that the court ultimately determined a range of 41 to 51 months, or approximately 3 to 4 years, and then imposed a sentence of 3 years, which was slightly below the guideline sentence. Without the Dao Zhao funds included, it would have been a guideline range of 33 to 41 months. And during the sentencing itself, the judge clearly said that if she was basing her sentence only on the first count, she would have imposed a sentence of probation for a whole list of reasons that she then went into. So there was a dramatic effect on the sentencing guidelines. And also, with respect to restitution, restitution is allowable for the charged offense and not for the relevant conduct. And so restitution to Mr. Dao Zhao was ordered as a part of this because it was considered relevant conduct, improperly so, as we set out in our brief. The second issue has to do with the due process violation. Now, ordinarily, of course, in a sentencing, a judge is within its discretion to decide the facts and issues on the day of sentencing. What differentiates this case from that particular scenario is that the defendant made clear through his counsel that he wanted a bifurcated sentencing, that because of the odd way that the plea transpired on the second day of trial, and without the government insisting on its right to go forward with the trial on count two, they wanted a separate determination whether the court was going to agree with Mr. Kyrie that the count two conduct was not relevant conduct, or whether the court was going to agree with the government that it was. And that was important to him for a number of reasons. Most of all because it depended upon the outcome of the hearing. And at the hearing, witnesses testified, including Mr. Kyrie himself. And it would have been important for him to know, and in fact, it turned out to be extremely important for him to know, whether the judge had credited his testimony or she had not. And the fact that he wasn't able to know this resulted in his attorney not properly preparing him for sentencing.
Couldn't the attorney have prepared in the alternative? Because the judge did say when the judge delayed this determination and then said, I'm going to give you a break between my determination and the sentencing, couldn't the attorney have prepared in the alternative and said, if the finding is X, we're going to argue this. If the finding is Y, we're going to argue that?
Well, it's certainly a possibility, although I would say the way things transpired in this case, the timing was not sufficient for him to have done that. He was proceeding on the belief that he was going to get this decision before the time of sentencing, and in fact, as sentencing approached, he filed another motion asking that it be delayed specifically so that he could have that decision. A motion which...
Here's what I'm trying to figure out. When the August 2023 evidentiary hearing wrapped up, Judge Rowland promised only that she would resolve the issues as to the Zhao transaction at the start of the sentencing hearing. And there was no objection when she announced that plan. So, I mean, in what sense was there a process, a due process, a process violation here?
Well, Your Honor, prior to that hearing, she had agreed with Mr. Kyrie's counsel to have this bifurcated hearing and to make it possible for him to have the decision prior to the ultimate sentencing. The expectation of the parties at the time of the hearing was that she would rule at that time. She said she wasn't going to rule at the time. She was going to take some time to consider it. And I believe that Mr. Kyrie's attorney and he were proceeding on the belief that, as she had stated before, they would have the results of that hearing prior to the ultimate sentencing.
But
So,
at the conclusion of the August hearing, she made clear she was not prepared to rule at that time,
she did.
but would instead rule, on the Zhao transaction at the start of the subsequent sentencing hearing, and no objection. So, you speak up if you feel you've been promised a ruling prior to the sentencing date.
I agree, Judge. That would have been the better practice in this case. It did not happen, and I believe, based on what transpired subsequently, when Mr. Kyrene's counsel asked, by filing a motion closer to the sentencing date to delay the sentencing for the purpose of having that decision, that he was acting on the belief that things were going to proceed the way the judge had originally agreed when he filed his motion for a bifurcated hearing.
Ms. Gambino, we will give you some rebuttal time.
Thank you, Judge.
Now we'll move Ms. Stern to you for argument on behalf of the government.
May it please the court, Stephanie Stern on behalf of the United States. This court should affirm defendant's sentence because the district court's inclusion of the Zhao transaction as part of the overall losses was proper, was based on the prior record and evidence, and therefore was not clear error. Defendant argues that this is about relevant conduct. That is incorrect. Defendant pled guilty to wire fraud, which includes as an element a scheme to defraud. That scheme to defraud was described in the first 4 pages of the indictment and included specifically allegations related to victim Zhao. After the guilty plea, defendant and the government disputed whether the Zhao transaction should be included as part of the overall scheme to defraud and asked the court to determine that at a later date prior to sentencing. There was an evidentiary hearing on the Zhao transaction. There was subsequent briefing by both parties on the Zhao transaction. And at the sentencing hearing, the court determined 2 things. First, that the Zhao transaction was properly part of the course of conduct related to the overall scheme. The court specifically said that defendant used Zhao's money to cover up his earlier losses in an attempt to cover up his earlier losses related to the fraud on victims 1 through 3. So the Zhao transaction was related to the earlier fraud because it was a cover-up, an attempt to cover up what he had done before. As to whether or not it was unlawful conduct, the court concluded that it did not credit defendant's testimony, instead felt that it was unlawful conduct. The court based this on the evidence presented during the evidentiary hearing and the argument by both parties, specifically pointing to 3 documents it found persuasive. First was the membership agreement between defendant and Zhao. This membership agreement made no mention of Primrose, which was what defendant claimed he was selling to Zhao. Instead, the membership agreement said that defendant and Zhao would together form a separate company that would purchase units in RFA. So no mention of Primrose, only mention of RFA. The other document that the court relied upon in its decision was the Primrose operating agreement, which specifically prevented defendant from selling Primrose shares to anyone during the time period that he allegedly sold his shares in Primrose to Zhao, according to him. And then the third document that the court relied upon was a summary document created by a government agent, which showed that after Zhao sent his money to defendant shortly thereafter put it into the Alpha Fund. At the time that defendant put it into the Alpha Fund, which had previously had $200,000 of victims 1 through 3's money, had gone all the way down to $17,000. So defendant claims that there's no evidence of the cover-up besides the fact that the money was moved into the Alpha Fund, but it's also the timing of when the money was moved into the Alpha Fund. At the time, as the court noted, defendant was deeply underwater with relation to his first 3 investors and was seeking some way to recover from his losses. He took that $100,000 that was moved into the Alpha Fund, used approximately $84,000 of it to invest in a high-risk shares, presumably in hopes that he could make up the money that he had lost. So the court's determination regarding both the course of conduct and including the Zhao transaction in the overall course of conduct, and determining that it was unlawful conduct was based on the prior record and therefore was not clear error.
How long was the evidentiary hearing, and how many witnesses testified?
The evidentiary hearing was a one-day hearing. I'm not sure exactly how many hours it took. I know that defendant testified, a government agent testified regarding the finances, and a member of RFA also testified during that hearing.
So 3 witnesses total?
Correct. And prior to that hearing, 2 victims testified. Zhao testified in a deposition, and so did Victor Lang, who were both foreign nationals, and so they testified remotely.
And then, of course, there was the documentation that you also referenced.
Correct. In subsequent briefings, the government included numerous documents supporting its position that this was unlawful conduct and this was an attempt to cover up his losses from the previous 3 defendants, or 3 victims, pardon me.
So we have remote witnesses, we've got the evidentiary hearing, we've got documentation, and then how many rounds of briefing after that are there?
Defendant filed a briefing immediately after the evidentiary hearing on the evidentiary hearing, so that was 1 round of briefing. After that, both parties submitted their version of offense for the PSR that also discussed the Zhao transaction, and defendant continued to maintain that the Zhao transaction was lawful there. Then after that, there was the sentencing memorandum, where defendant again claimed that this was a lawful transaction and it was just a simple sale. So there had been numerous briefings on the issue, and that didn't even include the motion to dismiss, where the same issue was briefed following the first 2 victims' deposition testimony. In addition, as to prejudice, as this panel discussed previously, there is, based on the timing of the court's statements regarding when it would rule, there was no prejudice here. Rule 32 only requires a determination, a sentencing on a disputed sentencing issue at sentencing. That's what the court did here. So there's no legal rule that requires the court to issue a determination prior to sentencing. The defendant was well aware that he might have to, address the Zhao transaction. He might lose on the Zhao transaction at sentencing, or he should have been well aware. In addition to the fact that the district court said at the August hearing that she was going to rule on the date of sentencing. Prior to the sentencing date, defendant had filed a motion to extend sentencing, stating that he wanted a ruling on the sentencing issue before the sentencing date. The court denied that request 4 days before the sentencing hearing. So at this point, defendant knew he was not going to get a decision before the sentencing hearing, had 4 days to prepare for 2 alternatives, and should have used that time to prepare for the fact that he might not win on the Zhao transaction issue. Moreover, the prejudice claim, there is no prejudice based on either the fact that defendant could have presented additional evidence as he claims, or that he might have changed his allocution. Defendant says that if given the opportunity to have more time to ruminate over the district court's decision, he might have presented additional evidence. It seems highly unlikely after a full day evidentiary hearing, after multiple briefings on this very issue, that there is any additional evidence to present, period, let alone any additional evidence that would present clear error regarding the district court's decision. As to changing his representations to the court, it's unclear how this would have changed the outcome. The district court mentioned that she was particularly concerned regarding the Zhao transaction because, one, unlike the first 3 victims, the Zhao transaction was a more direct fraud. The first 3 victims, he maybe started out with intentions to have a successful investment, and then he got in a hole. With Zhao, the court found that the entire interaction was fraud from the very beginning, and that was very troubling to the court. In addition, the court found it troubling that the defendant had consistently represented to it, including in testimony before the court, that he had done nothing wrong, and based on her review of the documents, the story he was telling her in court, in testimony, was not consistent with what she was seeing with the documents, so she was concerned about that. So even if, the district court had issued its ruling and then the defendant had made a belated allocution regarding DeJow, it's unclear how that would have changed all the other factors affecting the court's decision. Moreover, looking at the defendant's briefing, it doesn't appear that he's even ready at this point to admit that his conduct related to DeJow was unlawful. So unless there are any further questions for the court, I would ask that you affirm the district court's decision. Thank you.
Thank you very much, Ms. Stern. Ms. Gambino, we'll go back to you. 2 minutes for rebuttal.
First of all, although there was a scheme to defraud alleged in the first count that included DeJow, Mr. Kyriem was very specific in not pleading to those facts. So there was no basis for a finding of guilty with respect to the DeJow conduct based on his plea. It's clear also that the court did not understand how the Alpha Fund worked. The money that was deposited into that fund would not cover up any losses, particularly because they were to be distributed and accounted for based on the original shares and quantities and nature of the agreement of those investors. So there was no connection between DeJow's transaction and the Alpha Fund transaction. With respect to the documents that were submitted to the court, those documents were used to establish whether the court believed there had been unlawful conduct or not, but not whether those documents did nothing to tie the DeJow transaction to the transaction to which he had pled guilty. And 4 days is simply not enough time to prepare based on the what the judge's findings were. And she specifically commented when she was sentencing to him that it was clear that she not only admitted, but it was very clear that she didn't understand the nature of that transaction, and said that it disturbed her that he didn't mention it in his allocution, and of course he didn't mention it in his allocution because he hadn't been prepared for that. And the court had made a number of findings, which I think it would have been or fallen under the category of notice under Rule 32H, that he should have been aware of before he went into sentencing, because she found that he was not credible and made some specific factual findings with which he disagreed. And he would have had an opportunity to rebut those had he had the decision in advance. It's very hard to do something like that on the fly because you don't know how the judge is going to rule, and you can't adequately respond to the judge's concerns when they're very specific and fact-based and come out of a hearing that took place, and when you're expecting to have some time to respond to that in a thoughtful and careful manner. So there was prejudice to him because the judge was very upset, or seemed very concerned about him not including this whole transaction in the allocution for which he had not been prepared. So we would ask you, Judge, to reverse and remand.
Thank you, Ms. Gambino. Thank you, Ms. Stern. The case will be taken under advisement. We'll move now to our final oral argument today. This is Appeal 22-2830, Norberto Torres versus Kent Brookman et al. Mr. Williams will begin with you. Oral argument on behalf of the appellant.
May it please the court. Brian Williams for the appellant, Norberto Torres. This court should reverse the decision below that granted summary judgment for defendants because the conditions in Mr. Torres' segregation cell, a toilet that was leaking feces, the presence of mold and insects and rust, and the denial of bedding for several days was an atypical and significant hardship. And contrary to defendants' new arguments on appeal, there was competent evidence at summary judgment that created material fact disputes. Mr. Torres has a liberty interest in the conditions of his confinement. And contrary to the district court's decision below, that was wrong for two reasons. First, the district court improperly considered the length of Mr. Torres' sentence when conducting this inquiry. And second, the district court wrongly weighed the combination of the length of Mr. Torres' sentence with the conditions of his confinement.
Mr. Williams, the record here is a bit of a challenge. We've got certain allegations in the complaint, then we've got Mr. Torres' deposition, then we've got this filing that comes in response to summary judgment. We've got the response, an affidavit, and then a jurat, which talks about Illinois rather than federal. Should part of our disposition here depend on whether or not there's consistency in the allegations made with regard to, for example, feces in the cell?
There's ample evidence in the record, Your Honor, that there was feces in the cell, and there's 3 places that you can look. The first you mentioned, it says at appendix page 11, the allegations of the complaint, which Mr. Torres incorporated by reference in his response to summary judgment. Second, Your Honor, would be a letter that Mr. Torres wrote to the warden. That's at appendix page 28. And in that letter well, let me start, actually, go back for one moment and just put in Mr. Torres' words his descriptions of the conditions of the cell.
And this is from where?
And this is at page 11 of the appendix in his complaint. He said that he, quote, showed the warden when he flushed the toilet, smelly water would come out of the bottom. Also, a small amount of feces when he and his cellmate took a bowel movement. So that's in the complaint, which again, at page 171 of the appendix, he incorporates that reference. He refers back to those allegations. Second, Your Honor, is a letter that he wrote to the warden. And in that letter, he said, quote, I showed you the mold and the leaking, smelly toilet. That was attached and also was incorporated into it was attached to the complaint and was also incorporated by reference in his response to the motion for summary judgment. And third, in the response itself at page 171 of the appendix, he also refers to these allegations again. And he says that his, quote, due process was violated in that the conditions of his confinement was inhumane, in which the toilet to his cell was leaking underneath with toilet backflush. There were signs of mold and mildew and insects everywhere.
Why doesn't it get into the deposition then?
So if you look at the question that was asked, Ron, this is at page 120 to 122. The question was not asked, what were the conditions that you experienced in the cell? There was a broader question that was asked about what his claims were. And he does go through some of the issues that were in the cell. He does talk about the toilets not functioning and the mold and the mildew. But it wasn't a question that was asking him, like happened in some other depositions in similar cases, where they're specifically asked, what were the conditions? What are you complaining about here? And a defendant, a pro se plaintiff doesn't have to repeat himself in multiple filings in order for there to be competent evidence. And on that point, Your Honor, I think it's worth noting that the district court itself found that there was competent evidence. On pages 8 and 9 of its decision, it refers to the evidence before the court that it was relying on. And it cited specifically to the response to the motion for summary judgment. If I could go back to the first point, Your Honor, this issue of the district court taking into account the length of Mr. Torres' sentence. That has to be wrong as a matter of law. Prisoners with longer sentences do not have fewer constitutional rights. But if you take that to its logical conclusion, that's exactly what the district court held and what the government's position here would lead to.
Counsel, if we do find a liberty interest, what's your violation? What do you think was missing in the adversarial, the informal, non-adversarial due process?
There are at least 2 issues, Your Honor. First would be the refusal to allow him to present witnesses, but not only that, the complete failure to give any reason for that. So that's the first part of it. And the second part of it was also that he wasn't given any of the evidence below that was relied on in his disciplinary proceeding. So Mr. Torres noted that he didn't get the gang questionnaire that was he had allegedly filled out, nor was he given the documents that they used for the handwriting example that they allegedly used to compare the gang questionnaire and his handwriting to the other documents. And so there's those 2 issues. And Your Honor, even further, the grievance office itself, at pages 150 and 151 of the appendix, expunged this infraction because they found it was procedurally improper. And so unlike some of this court's other decisions where there wasn't necessarily a due process issue, Those cases didn't involve one like here, where the state grievance office itself found a violation of due process. And again, the district court didn't find an issue on the procedural due process. It found that there were disputes of fact on some of these procedural issues and really turned to the liberty interest. And that liberty interest analysis was really the crux of the district court's opinion. And the district court's analysis on that liberty interest was wrong for a few reasons. Besides the issue of focusing on the length of Mr. Torres' sentence, he also didn't give sufficient credit to the issues of the cell, and particularly the human feces in the cell. This court in Williams v. Brown, it's an unpublished decision, but in that decision, this court said that if the allegations in the plaintiff's complaint were true, that he had been, quote, subjected to feces and urine, that would be sufficient to state a liberty interest. And that also shouldn't be controversial. That several courts, both in other circuits, but also in district courts within this circuit, have found that. And in fact, in 2 cases in the district court involving these very defendants, that's Basemore v. Brookman and Neal v. Veith, both district court decisions where, in one of them related to this particular facility, there were feces on the wall. And the district court in that case determined that that was sufficient to implicate a liberty interest. And that should be the case. And in neither of those cases below did the district court have concerns with the evidentiary standard, even though in both of those cases, and particularly I believe in the Brookman case, there was an issue of that the plaintiff had only put his allegations in the response as opposed to in a formal affidavit. But the district court still credited that under this court's precedence that we don't hold pro se plaintiffs to the same standard. And on these facts and those conditions, the district court erred in finding that there wasn't a liberty interest. With that, I'd like to reserve the remainder of my time for rebuttal.
Very good. Thank you, Mr. Williams. Mr. Bichat, we'll move to you now for argument on behalf of the appellee.
Thank you, Your Honor. May it please the court. My name is Frank Bichat, and I represent the defendants. This court can affirm summary judgment on several grounds, but I intend to start with the one that is the most straightforward, which is that even if the challenged discipline did implicate a protected liberty interest, the disciplinary hearing comported with due process under this court's decisions, most notably in Adams. In Adams, this court held that an inmate who does not lose sentencing credit is entitled only to informal, non-adversarial due process. The court then explained that informal, non-adversarial due process consists of adequate notice and an opportunity to present his argument to the decision maker. Under the facts of that case, the court held that due process was not violated because the plaintiff did not ultimately lose any sentencing credits, and he was given the opportunity to orally present his arguments to the decision makers. Adams is directly on point with this case. Here, the plaintiff also did not lose any sentencing credits, and therefore the informal due process is the standard that applied. The plaintiff doesn't dispute that.
He may not have lost, any good credits, but he had to spend 3 months in that filthy cell.
That's true, Your Honor, but in Adams and in other cases like Ely and Westerford, this court has recognized that the amount of process that is required is dependent upon whether or not the plaintiff, the inmate, loses sentencing credits. And in fact, in Whitlock, which is one of the cases that the plaintiff cited in their reply brief, this court explained that sort of the reason for the Wolf requirements, which include a limited right to call witnesses, is those requirements are there to protect an inmate's very important interests in not losing sentencing credits. And so under Adams and this court's other cases, they compel the conclusion that the plaintiff received the adequate informal due process here. Again, the two points of contention are essentially identical to what was in Adams in both cases. The plaintiff argued that he was denied the opportunity to call witnesses without reasoning. in Adams, the other evidence was video evidence. Here, it was the evidence of the questionnaire and handwriting evidence. Those are very much analogous. And so,
Is it your position that a prisoner lacks a due process right, for instance, to a witness at a disciplinary hearing, resulting in assignment to segregation as a punitive matter, even when the conditions of segregation are atypically harsh? Because that seems like an extraordinary assertion to me.
well, yes, I mean, that's what this court held in Adams, based on Hewitt and consistent with other cases. The process that the plaintiff said that he wasn't provided with was the opportunity to present witnesses and to see the video evidence. And even under the informal process that's contemplated in these cases, there is process. You know, the plaintiff does get notice here. He got 8 to 9 days of notice ahead of time. The plaintiff was also given the opportunity to present his arguments orally to the decision maker. I mean, in Adams, this court, citing Hewitt, pointed out that a written statement to that effect would usually be sufficient, but here he was able to do it in person. And in the grievance process, there's also then, you know, later reviews of the decision, which in this case did ultimately result in reversing the decision.
Mr. Bestrat, same question, similar question I posed to Mr. Williams. The record we have here is not crystal clear. We've got the complaint, and Mr. Williams has helpfully given us the record sites. We've got a deposition, which doesn't mention some of the words we've indicated in the past might reach that level of being a conditions of confinement claim. Then we've got this response to the summary judgment, which looks like 2 or 3 documents smashed together: response, affidavit, and then the jurat, not a federal declaration under penalty of perjury. What are we to do with this record from the state's perspective?
Well, I think there's 2 things this court can do. First is to interpret the declaration, even though it wasn't a federal declaration. I'll call it a declaration, just I guess for simplicity, that the declaration applied only to the affidavit and not the response that preceded it. And then also secondarily that even if this court considered, you know, the response and the complaint and the letter, that it should find that there was no protected liberty interest anyway. Onto the declaration, I think what you have is you had a memorandum of law that was followed by an affidavit of service, that was then followed by the plaintiff's affidavit, and then that was followed by the declaration. Many of the allegations in the affidavit were included in the response itself, and so I think that indicates that the plaintiff had intended for the affidavit to be separate from the response itself. Otherwise, there would have really been no purpose to adding the affidavit, and therefore that the declaration applied only to the affidavit. But also, if this court disagreed with that and considered everything in the response as well, I think we would still end up in the same situation where there is no protected liberty interest because the allegations were very minimal and vague. Really, the most, I guess, specific allegations are probably in the complaint. That's really where the only point where the plaintiff had specifically mentioned anything about feces, and there he says that there was a small amount of feces when the toilet was flushed at certain times, and you know, from this problem existing so long, it created smelly mold on the side of the toilet. The smelly mold on the side of the toilet was then referenced again in the letter, and under.
May I go back with you to Adams for a moment?
Yes, Your Honor.
Yeah. That's a very unique case, you know, in that the disciplinary proceeding in question was one of 8 proceedings that later led to the prisoner's transfer to long-term department-wide segregation. And you know, the Supreme Court and this court have distinguished such transfers and reclassification decisions from the run-of-the-mill disciplinary decisions, and have really emphasized that The former require only a very informal process and limited right to be heard. And by contrast, this case was the more typical disciplinary case in which a factual determination was made for disciplinary purposes. And of course, he was assigned to segregation as a punitive matter. And in such cases, we have always said, to my knowledge, that a prisoner has a right to call witnesses on his behalf, so long as the witness requests are consistent with institutional safety, with prison safety. He was denied that right without any reason being given. So it seems to me there is a viable claim for denial of procedural due process.
A couple points in response, Your Honor. One is that the opinion in Adams, I don't think drew that distinction. It really focused on whether or not there was a loss of sentencing credit. That was the defining line that the court followed. And that decision is reflected in this court's subsequent decision in Ely, which came out this summer, and it's also consistent with Westepher, that's the point at which the court draws the distinction between when the more formal Wolf process is required and whether the more informal non-adversarial process is required. And I know this isn't determinative, but I would be remiss if I didn't point out that the defendants have not conceded that the plaintiff requested witnesses and that his request was denied without any explanation. There was a question of fact on that. We've argued that he didn't request witnesses, and as in Ely, I think there's no documentary evidence showing that he did. His assertion, I believe, is that at the hearing itself he requested witnesses. So I just want to make clear that we're not conceding that. And I know I'm running out of time, so I did want to briefly respond to the point that opposing counsel raised about the length of sentence. Whatever error the district court might have made by considering the length of sentence, the district court then went on to consider the conditions of confinement in this case. So even if this court were to agree with the plaintiff that the district court shouldn't consider the length of the actual criminal sentence, that would be harmless error because it didn't factor into the ultimate decision. So unless Your Honors have any further questions, we would ask that you affirm.
Thank you, Mr. Bestrat.
Thank you.
We'll now move Mr. Williams back to you for rebuttal.
Your Honors, if defendant's position is correct, Mr. Torres could have spent 10 years in segregation, waist deep in feces, and no more process would have been due. That isn't right under this court's precedents, and that shouldn't be your decision today. This court should instead continue the line it started to draw in Williams v. Brown, where if a prisoner is subjected to a cell that's riddled with feces, that implicates a liberty interest. And in that situation, whereas here there's been a procedural violation that's been recognized by the state grievance office, that is sufficient to determine that the prisoner's 14th Amendment due process rights were violated. For those reasons, we ask this court to affirm.
Thank you.
Excuse me, to reverse.
To reverse. Thank you, Mr. Williams. Thank you, Mr. Bestrat. Mr. Williams, you and your firm were appointed counsel for this case, and you have the great thanks of this panel and the court. Excellent advocacy by both sides. Thank you very much. And the court will stand in recess.